Good morning, Your Honors. I'm Barbara Basharis, representing Wayne Doty, and I've requested to reserve 5 minutes of my time for rebuttal. Thank you, Your Honors. Your Honors, Mr. Doty is asking you today to reverse his sentence of death and remand his case for a new penalty phase at which the jury can be instructed on the correct burden of proof to be applied to certain findings that had to be made before death could be imposed. As the court is familiar, this is Mr. Doty's second sentence of death. He was initially given a death sentence based on a non-unanimous jury recommendation and then was resentenced following Hurst v. State. However, the main issue that he raises on appeal is the instruction of the jury on what has to be found beyond a reasonable doubt before death can be imposed under the current Florida statute. Your Honors, as you're very familiar, in 2016, the Florida legislature made some significant changes to Florida's death penalty statute in response to the Supreme Court decision of Hurst v. Florida. Hurst v. Florida said that the Florida statute previously in existence was unconstitutional because it allowed judicial fact-finding of certain key issues, particularly the existence of aggravating circumstances justifying the death penalty. In response to that decision, the Florida legislature made some significant changes to the death penalty statute and put several key findings squarely in the hands of the jury, so that now we have a system where before death can even be considered, the jury has to go through several steps, make findings on those steps, and then recommend death. And only if those things happen does the court then exercise its discretion to impose death or to give the defendant life in prison without possibility of release. Those steps are, first, that one or more aggravators have been proved, aggravating factors. Second, that the aggravators are sufficient to justify death. And third, that they outweigh any mitigating evidence that's presented. And it's our position that under Hurst v. State, under Perry, and under Supreme Court case law, that because those findings are in the hands of the jury, they must be made beyond a reasonable doubt by a unanimous jury. The unanimity requirement, as you know, was not actually added to the statute until 2017 following Hurst v. State. But now we have findings that must be made by the jury. We have a requirement of unanimity. And hand in hand with that goes the requirement that these findings be made beyond a reasonable doubt.
Hurst v. State, though, did not require that those findings, other than whether there was an aggravating factor, be made beyond a reasonable doubt, correct?
I don't agree with that, Your Honor.
Which part of the opinion says that it mentions beyond a reasonable doubt with regard to those other facts that need to be found by the jury?
What Hurst v. State does, Your Honor, is it distinguishes between findings that the jury makes and recommendations. And Hurst acknowledges that under the Apprendi line of cases, findings that increase the maximum penalty have to be found beyond a reasonable doubt.
Didn't Hurst specifically use the beyond a reasonable doubt language only with regard to the first fact that has to be found by the jury, whether there was an aggravator?
In one of the statements of the case is holding, yes, Your Honor, you're correct. It
Okay.
referred specifically to that. Of course, that makes sense in the context of the statute that had been invalidated.
How can one make beyond a reasonable doubt? How can one assign a certainty level to a factor like mercy or to a weight, weighing one versus another? How are those susceptible to a standard of proof, whether it's beyond a reasonable doubt, preponderance of the evidence, or whatever?
I believe those two factors are treated differently under the statute and can constitutionally be treated differently, so that the jury's ultimate recommendation of death or life is the so-called mercy determination. And that is not susceptible, as you said, to a specific burden of proof.
What about weight? What about where you weigh?
The weighing is, and in fact, that weighing decision is subject to that burden of proof in a number of other jurisdictions and other decisions as well.
I know other jurisdictions say it, but I'm talking about just a matter of practice. How would when you're asked to weigh one versus another, and you're saying one weighs more than the other, how is that susceptible to beyond a reasonable doubt or preponderance? It either does or does not weigh. It's a
Because, Your
It's
Honor,
a judgment call.
The weighing itself is a judgment call, yes. The state of certitude that has to be brought to that ultimate recommendation is something that can be... I'm sorry, Your Honor?
Does a jury have to unanimously find beyond a reasonable doubt a mitigator before it can be considered and weighed?
No, Your Honor.
Why not?
Because a mitigator does not raise the available statutory maximum penalty. A mitigator recedes from...
How can you say when the finding of a mitigator, whether someone individually considers something as a mitigating circumstance, is an individual determination that's sort of qualitative? One person can, one person can't. But then that somehow the weighing of aggravators and mitigators has to be beyond a reasonable doubt. I mean, that just seems completely illogical and inconsistent.
Your Honor, it's not inconsistent. It has to do with who has the burden of proof for what. When the state has to prove something that's going to raise the penalty against a defendant, the state must do so beyond a reasonable doubt, and that's grounded in the right to a jury trial. If the defendant has to show something that might mitigate that sentence, that might get the court or the fact finder to step back from that ultimate penalty, the burden is not on the defendant to do that beyond a reasonable doubt. The beyond a reasonable doubt standard as it relates to the weighing, again, has to do with the certitude that you bring to that conclusion. These aggravators outweigh these mitigators.
Didn't we reject and foster that these elements that you're talking about, the weighing factors, are in fact elements rather than sentencing factors, don't fall within the Apprendi line of cases, and therefore do not have, are not required to be proved beyond a reasonable doubt?
Your Honor, I think if you read Foster that way, if you take it to that extreme, it's clearly not concurrent with Apprendi in the line of cases, and that's of course why it's being, review's being sought now.
Didn't quoting Winship, we say that the beyond a reasonable doubt standard only extends to every element of a crime, every fact necessary to constitute that which is charged, and then we said that the Hurst penalty findings are not elements of capital first-degree murder, and the jury properly considered those elements under...
Your Honor, I would agree that they are not the elements of a crime of first-degree murder, but under Apprendi and that whole line of cases, including Ring, including Hurst v. Florida, a finding does not have to be limited to one of the original elements of the charged crime for it to be a finding that increases the maximum penalty available.
Didn't we reject this very argument in Foster, following both Perry and in Hurst?
Your Honor, I don't think it's necessary to read Foster that broadly. Of course, you may understand it better than I do, but I think if that's how you intend Foster, then Foster is in direct conflict with Apprendi in that line of cases, which make absolutely clear that a sentencing consideration that enhances the maximum penalty has to be found beyond a reasonable doubt, even if it's not an element of the original crime.
How do we square that with our jury instruction case, where this specific argument was brought to our attention by some very sophisticated litigants, and this court unanimously, I believe, or almost unanimously, rejected that and adopted the instructions that were actually given in this case?
The court adopted a set of instructions without specifically ruling on this issue or expressing an opinion one way or another.
Someone asked us to add beyond a reasonable doubt to the exact factors that you're talking about, and we did not do so.
That's
right? Correct,
but again, without explanation. And so I think your honors would agree that when the court does not provide a rationale for something, that it may be, it's still arguable later on, basically.
Can we also assume that we considered it and rejected it?
That has happened in the context of other jury instructions where the court has actually explained why some change was accepted or not accepted. In this case, we do know, you're correct, that that language was discussed or at least proposed in connection with those factors. I went back and watched the oral argument on those jury instructions, and it seemed to me that where it was really sticking was, again, on that ultimate weighing weighing decision, the mercy decision, and whether that was susceptible of proof beyond a reasonable doubt, which is not what we're urging here today. We're talking about the weighing decision, the certitude that the aggravators outweigh the mitigators, and then the finding that those aggravators are sufficient to justify death. And I would also just cite the language in the jury instruction decision, which is in all of this court's decisions, I believe, issuing jury instructions, that nothing in that opinion forecloses additional challenges to the jury instructions. So I don't think the argument that we're making here is foreclosed in any way by the fact that the court adopted those standard instructions.
What do we make of the U.S. Supreme Court statement in Carr that the weighing element, the quote, ultimate question whether mitigating circumstances outweigh aggravating circumstances, is mostly a question of mercy, the quality of which, as we know, is not strained? It would mean nothing, we think, to tell the jury that the defendants must deserve mercy beyond a reasonable doubt or must more than likely or not deserve it. Isn't that exactly the concern that we're talking about here? It's not subject to a standard of proof?
It is the concern, Your Honor, but it is a concern raised in the context of a different statutory scheme. What we have here in the Florida statute post-2016 is a system where the Florida legislature gave certain findings to the jury before that mercy decision can be made. So there are statutory schemes where once an aggravator is found, everything else becomes a question of mercy. Here, we have a system where merely finding that aggravator is no longer enough. That's shown by the way the sections of the statute work together.
Yeah, but even the mercy determination is statutory now after the change is made, correct?
Correct.
So why would that not be a fact? You've now conceded, I think, that that is not subject to beyond a reasonable doubt. Why, if that's part of the statutory scheme, is that treated any differently than any of the other post-aggravating factor determinations?
Because the other determinations are findings that have to be made before death can be considered. Once you get to the point where you're considering death, then you're in a different category.
But it's true of the mercy consideration too. Death cannot be considered by the trial judge, cannot be imposed until the jury determines that there should not be mercy, correct? Unanimously.
That's true.
How is it any different?
But the difference there is that the judicial decision at that point becomes really an additional layer of mercy. We don't have a judicial override where a jury can recommend life and a judge can still recommend death or impose death, as they still have in Alabama, I believe.
I'm just having trouble understanding how in Kansas, where there needs to be, before death can be imposed, a weighing that is not susceptible to a standard of proof, but this somehow, our scheme somehow is. I'm having trouble reconciling that.
It has to do, Your Honor, just with where you draw the line between when that death penalty truly becomes available under the particular state statute. In many state statutes, you have aggravators that are built in to the definition of murder, for example, so that the charging itself leads to limiting the cases to which the death penalty can be imposed. In Florida, we do that by having aggravating factors that have to be proved beyond a reasonable doubt, and since 2016, these additional jury findings that Hurst and Perry both said had to be made unanimously, and Perry directly said beyond a reasonable doubt by a unanimous jury.
You argue in your brief that Foster is inconsistent with Hurst v. State and Perry, and you're arguing that now.
Yes, well, with the entire Apprendi line of cases.
Okay, well, I agree with you that it's inconsistent with Hurst v. State and with Perry, that Foster is. Perry is the later pronouncement in 2018. Assuming that Perry is correct, that we believe that Perry is correct, would it be helpful to clarify what parts of Hurst were wrong, Hurst v. State and Perry? Because, I mean, it's obviously confusing if we have inconsistent pronouncements and we haven't said explicitly that one is wrong.
Yes, that would be helpful, I think, to all litigants, Your Honor, and I think that Foster has to be limited to be brought into the scope of the existing case law on what has to be found beyond a reasonable doubt by a unanimous jury. I think that the court recently issued another decision, the Brown decision, which I believe Your Honor wrote that opinion, which involves the Apprendi line of cases and reiterates the court's adherence to Apprendi. I think that decision actually provides some analogous circumstances to the situation we have here, because there you had a crime that was subjected to a theoretical range of sentences of third-degree felony, so it could get anything up to 5 years, but then you had a statute requiring looking at the criminal punishment code and then requiring a separate finding of potential dangers to the public if a lower CPC sentence was imposed. So you had the theoretical range, just like we do here. Once you're charged with certain first-degree murders, the theoretical range is all the way up to death. Once a death panel is impaneled, that's your theoretical range. But there are certain things that have to be proven before that sentence can even be considered. And as the court said in Brown, those things have to be found by a jury. And it's our position that if it's a jury finding, it clearly requires unanimity, and we believe it requires proof beyond a reasonable doubt before you move into the more discretionary part of sentencing. I believe I'm into my rebuttal time, Your Honor, so I'll reserve the rest of my time. Thank you.
Chief Justice Kennedy, Justices of the Court, may it please the Court. My name is Jennifer Donahue. I'm an Assistant Attorney General, and I represent the state in this case. This court should affirm the sentence in this case because there was no jury instruction error, as a burden of proof is not required for sufficiency in weighing, and the trial court properly considered and rejected the non-binding sentencing recommendation. Our statute is very clear that the eligibility for a death sentence occurs upon the finding of at least one aggravating factor beyond a reasonable doubt. After that, the jury considers whether mitigation outweighs the aggravators. And these considerations are just like considerations that any judge would make in sentencing. Judges' considerations in sentencing are not made beyond a reasonable doubt. We don't assign a burden of proof to that. It's determining which sentence is appropriate. So once the defendant becomes eligible for a death sentence, the jury is then deciding which sentence is appropriate in the case. The second issue was whether the court should have made a non-binding sentencing recommendation. As I recited in my brief, the court stated that it could make that recommendation, but decided that it was not appropriate in this case.
What do we do with Perry, though, which seems to be inconsistent with what you've just articulated here?
And perhaps it is inconsistent or
Would you agree that
unclear.
It is?
Yes, I believe that it's inarticulately written, and it would help all parties to more clearly and explicitly explain that the findings of weighing and sufficiency are not required to have a burden of proof. But I think the statute itself is clear enough that...
Is there a way to explain or to distinguish Foster from Perry, or are they irreconcilable?
Perhaps they seem irreconcilable. I believe that Perry...
Is it possible to distinguish them because Foster was interpreting a pre-statutory case that the statute had changed since Foster?
Perhaps that's one way that it could be distinguishable. But I believe Perry was merely inarticulate in saying that they were elements rather than findings, and perhaps the distinguishing feature is that the court meant to say that these are jury findings.
Well, let me ask you this. If they are elements, do you agree that if we were to find them to be elements, would you agree that they would have to be proved beyond a reasonable doubt?
Yes,
okay.
I would agree with that.
So the key is, are they elements or are they not? That's where this rises or falls.
Yes, absolutely.
Okay.
But they certainly don't increase the punishment. They're downward departures, so there's no reason that they should be considered elements under the Apprendi line of cases. The only other state that has made that determination is Delaware, and they read Hurst v. Florida very broadly, as they stated in their opinion.
What's the best statutory argument you have for the proposition you've laid out, which is that only the aggravating factor element or determination is an element which is subject to proof beyond a reasonable doubt. You stated that that's what our statute says. Where in the statute would we find that that's solely the gateway for which you were eligible for the death penalty, and the rest of the determinations are not elements for which you are eligible for the death penalty?
At 921-141 2B2, it specifically states that a defendant becomes eligible upon the unanimous finding beyond a reasonable doubt of at least one aggravating factor. And, the requirement for beyond a reasonable doubt for aggravating factors has appeared in the case law since the early 80s, so that's been something that we've been doing all along. Pending any other questions from this court should affirm the sentence in this case. Thank you.
Your Honors, regarding eligibility, it's correct that there's a section of the statute labeled eligibility, but we would say that you need to look at function in addition to form when you're deciding what the statute does and what it requires. If you look at the standard jury instruction and verdict form that this court approved and which was used, a version which was used in this case, the way that walks the jury through the findings that it has to make makes very clear that death is not considered until those additional findings are made. And in fact, in the jury form, the word eligibility is attached to the final finding.
I'm sorry, I apologize for interrupting. Isn't there a distinction between determinations which the jury is required to make in the course of its deliberations versus statutory eligibility for death as you articulated from the Brown case? In other words, what Apprendi says is only where the maximum sentence could increase or decrease based on a finding, that finding has to be made beyond a reasonable doubt and is an element of the case. Isn't our statute saying that what increases from mandatory life to death is the finding of an aggravator, and everything after that is whether we should or shouldn't?
I would disagree with that. I would say
Why
that
is
under the new statute, the statute since 2016, those additional findings are prerequisites to even considering death, that it doesn't become available.
But the recommendation, the unanimous recommendation, is a prerequisite, right?
As you said, the mercy decision, yes. And I agree, Your Honor, that that's not susceptible of proof beyond a reasonable doubt, because that's a judgment call that incorporates, a holistic view and has to be individualized to each juror.
I guess what I'm having trouble is if that is the case, and that is in the same statutory scheme and is treated the same as the weighing and the sufficiency factors, why would that one be treated differently and not susceptible to a standard of proof, but the others are susceptible proof and are elements?
Because it's the final step in the jury's determination. It is the decision that the jury makes about what sentence should be imposed as opposed to what has to be true before death.
But as a matter of reading the statute, they're not treated any differently, are they?
I would argue that they are, because if you don't get the initial findings, you don't proceed all the way to that final
That's true of mercy, though.
determination.
But that's true of mercy. You don't go any further if the mercy finding isn't made unanimously, right?
That's correct.
Then again, I'm just having trouble. If that is not susceptible to a standard of proof, and I agree with you, it can't be.
I would say, Your Honor, because that's the ultimate question that the fact finder has to decide, and it could end there. And we happen to have a procedure where the judge then has to impose the sentence and can impose a lesser sentence. But the actual sentence that has been imposed at that point is what the jury recommends, unless the judge backs down from it. That becomes that.
I'm just struggling to see how these determinations are findings of fact, as opposed to being basically making judgment calls, both the final step and the step before that. I mean, just qualitatively, they seem very similar.
Your Honor, they're not findings of fact in the sense of, did the defendant use a gun? Did the defendant fire 3 shots? But they are findings.
But isn't Apprendi and the whole line from the U.S. Supreme Court about findings of fact?
Well, but a lot of times those findings have to do with things like intent that are not objective facts, but which have to be inferred.
Still findings of fact.
once the jury decides that somebody had a specific intent, I believe in Apprendi there was a bias statute at issue, so once the jury decided that there was bias, then that became a fact. And here, once the jury decides that the aggravators outweigh the mitigators, and the jury is convinced of that to a high level of certainty, that becomes a fact. The aggravators outweigh the mitigators, and then you move on to the next step of the determination. So,
All right. We thank you.
thank you, Your Honors.
We thank you both for your arguments. The court will now stand in recess for about 10 minutes.
All rise.